Good evening. I'm Dolores Swearing-Yao, and I'm the Executive Director of the Westchester Community College Foundation. Thank you so much for joining us tonight for a topic that I know is so important to all of us for our future financial security. I'm delighted to introduce our speaker tonight, who is our new Westchester Community College Foundation board member, Sharon Cooper. Sharon has such an impressive resume, and I can't take time to read it all to you tonight, but let me just say that she has an undergraduate degree from University of Pennsylvania. She got her law degree from Columbia University, and she is an estate and trust attorney with the very prestigious law firm Cuddy and Fetter. As Sharon gives her presentation, if you have questions, please put them in the Q&A at the bottom of the screen, and we will get to just as many of them as we possibly can during the Q&A period after Sharon's talk. And now I'll turn it over to Sharon.
Thank you, Dolores. Thank you for that lovely introduction, and welcome to everyone who's joining us tonight. I am very pleased to be here, and I'm looking forward to giving everyone an overview of what you might need or expect when it comes to preparing your estate plan. As Dolores said, you can put any questions that you have into the Q&A. I'm not here to provide legal advice. Everyone's situation is a little different, so I'm giving mainly an informational talk this evening. But if you have questions as we go along, please, like Dolores said, please put them into the Q&A, and we will have ample time at the end of my presentation to discuss any questions that you may have. So I'd like to start by dispelling a few myths regarding estate planning, that it's primarily geared towards those with a lot of assets or those with complicated assets, and that it's focused mainly on the avoidance of estate tax. While people in those categories certainly need estate planning and can use many of the complex techniques that estate planning attorneys have devised over the years to minimize the erosion of wealth through taxation, there are many more important reasons to plan your estate, and most of those are focused not on what you have, but on who you are. Family relationships and dynamics can be nurtured or fractured in the wake of a death, particularly the death of a family matriarch or patriarch whose presence is the glue for the family. At a time of crisis and a time of stress, you want to have made for your family a plan, an instruction manual, so that they have some sense of what to do once you're gone. So why do you need an estate plan? Well, you'll see that I have tax planning down there at the bottom, like I described. Primarily, you want to make sure that your wishes are followed, that if you have particular assets that you want to go to a particular place, that they get there. If you don't have a will, the law will make certain presumptions about who is close to you and what would happen. And most of the time, those aren't what you would do. They'd be fine in a pinch, but really you deserve, after having worked your life to establish the assets that you have, to honor the relationships that you've established in your lifetime by making sure that everything goes where you want. Another reason is to make sure, like I alluded to, that you prevent uncertainty for loved ones. People want to know what's going to happen. At a time of crisis and stress, having some sense of certainty is extremely valuable. I frequently get calls from people in the immediate aftermath of a death saying, what do I need to do? And it's nice to be able to say to them, your loved one had a will, it's written down, right now you need to grieve, and we can work it through later because we made a plan. There's a little phrase that you hear from time to time, more in sort of the business section, but that failing to plan is planning to fail. To some degree, that applies here as well, because if you haven't made a plan, you may be causing more or unable to avoid problems that you could have avoided had you just written it down. This brings us to the topic of avoiding conflicts. Let's just say, for example, you have two relatives who you know don't get along. If they have an equal right to administer your estate in intestacy, you may end up with a huge conflict. Whereas if you do a will, you get to pick who's in charge, and you can manage some of the dynamic of those relationships by in your will, naming people who you know will be able to work together. Next, you can use your will to protect the people that you care about. You can certainly, if you have minor children, you'll want to make sure that you have appointed a guardian for them. That can be very, very stressful. Obviously, if only one spouse has died, when one parent has died, the other parent would be the guardian. But it does happen that both parents die when you have minor children, and that can be hugely stressful. I had a cousin had a friend whose parents died in a joint accident when she was 13. And as she described it, there were 2 harrowing weeks of her life when she didn't know who she was going to live with. That is terrible, and it shouldn't happen. And it doesn't have to happen. You can select who those people will be. You can protect your family by the use of trusts, as we'll discuss when we get to that section in the presentation, by making sure that the money that you have worked to earn won't be wasted and won't be frittered away, and can be preserved to make sure that it can help your family into the future. And then we do get to the topic of tax planning. Certainly, there are things that you can do to minimize tax burdens if you have one. So broadly speaking, the federal government right now gives every American US resident citizen an exemption of $12 million from estate tax. And it allows a couple to use both spouses' exemptions on the death of the second spouse. So that's $24 million that a couple can shelter from estate tax. That is not most people's problem. And it gives you a good buffer. Some states have their separate estate tax. New Jersey does not anymore have a separate estate tax. So if you live in New Jersey, that's not an issue for you. New York has an exemption that's just over $6 million, 6.1. And 2 spouses, if planned properly, can use both of those, and you can shelter $12 million. That's, again, a good hefty sum. Most people won't get there, but it happens. And if you don't plan properly, then you might waste one of those exemptions and not really be able to take advantage of the whole 12. I'm getting a little bit technical, and like I said, I don't want to get too granular here. These are the kinds of things you would discuss with your own estate planning attorney based on your own assets. But suffice it to say that if you do it right, it can be great. And if you don't, it can be not so great. And just Connecticut, as another border state, has an exemption that's currently, I think, $9 million and is changing. All of these exemption amounts can change. The federal exemption amount is likely to change, certainly at the end of 2025, if not sooner. We don't know how, we don't know when, they don't tell us. We just have to wait like everybody else and then scramble right before the law changes. It's happened before, it'll happen again. Carrie, I'll take the next slide and we can get started on basic estate planning documents. So the most basic of your estate planning documents is your will. And the will is essentially an instruction manual. It allows you to tell your family what you want to happen, from the very granular to the broad. So wills will dictate what happens to your tangible property, what happens to your other general property, and you can direct those assets to anyone that you choose. New York and most states don't allow you to fully disinherit a spouse without their permission. If you have a prenuptial agreement, maybe you have discussed waiving the spousal rights to inheritance. But most couples, at least, are intending to leave their property to their spouse in the first instance and then down to their children in some form. So typically the will start with gifts of tangible property. And that means your stuff, right? Your jewelry, your furniture, artwork. If you have a lot of artwork, you have to plan pretty carefully for that. But especially if it's all the artwork of one artist. If it's artwork you've created, there are other issues that you have to attend to, having to deal with preservation of an artist's legacy and a preservation of the property, both physically and in the sense of its moral rights. But it may be something as simple as you have a ring that you inherited from your great-grandmother and you want to make sure that it goes to your grandchild for who is named for that relative of yours. You can say that. You can make sure in your will that that's directed. You could also just because people ask, you can make sure that if you live long enough, you end up giving those things away directly, right? And you have the joy of watching someone receive it and enjoy it. But if it's important to you, you want to make sure that it goes in your will. Then you might have gifts of cash, token gifts to grandchildren or to friends or to relatives, just as a memento, or larger gifts. Maybe you've worked with a charity your whole life and you want to make sure that you've given some honorarium to that entity to make sure that they understand that it's important to you. Then you will direct where the rest of your property will go. Like I said, typically that goes to a spouse, but if not, maybe it's going to go to children. Maybe you're in a second marriage and you want to preserve your property primarily for your own children. That is something else that you would do in your will. So wills can go from the simple to the complex. Some people have property in different states and you have to account for the different state laws. You want to make sure that you honor the family relationships that you have, and that, like I said before, you don't create extra tension where there wasn't any. So maybe now you'll be considering who to name as your executor. The executor is the person who's in charge of what happens under your will. So for most people, that might be their spouse in the first instance, and maybe then it'll be their children. But again, let's say you have children who don't get along. You might be creating more problems by naming them to act together. On the other hand, maybe they get along well enough, and if you only name one of them, you're going to create resentment where there wasn't any before. Then it's really important to make sure that you've honored that relationship. Ultimately, again, you can make things harder or you can make things easier. So the executor will, upon your death, the person who's named as executor will present your will to the court for probate. And once they're appointed, they will be able to start gathering up your assets. And then they'll pay your debts and your expenses. And then they will pass the property on however you've directed it in your will. We'll talk about trusts in a little bit. There can be trusts under your will. And again, as we said before, if you have minor children, you'll want to make sure at this point that you've also put guardianship provisions into your will. When your children are small, that might be, a relative. It might not matter where they live. As your children get older, they may have more of a say. And so that's the kind of thing you want to make sure that you update from time to time. Also, as your life evolves, people come in and out of your life, their lives get more and less complicated. So the people that you've named to be in charge, either of your children, of your property, you'll want to consider from time to time updating those documents. Another document that people frequently use is a revocable trust or a living trust. This is sort of a will alternative. It's not the kind of trust that we'll discuss in a little while, some of which can have tax consequences. This is essentially an administrative vehicle. And it's something that we haven't always used very readily in New York. There are states where we use it all the time. Florida always uses revocable trusts for their planning. California uses joint revocable trusts as a community property state, which is complicated. Connecticut, if you're going to have any trusts under your will, you want to make sure that you're not under the auspices of the court for that you're in a revocable trust. And a revocable trust, as the name suggests, is one that can be revoked. So if you use that sort of a trust, you would optimally retitle all of your assets into the name of that trust, and you're the trustee during your lifetime, and you operate just as you always had before. Maybe you'll sign trustee on your check instead of not. The advantages of a revocable trust are a few. You can use it to avoid delay. So in the probate process, sometimes there can be a delay, and lately in New York, there has been some delay. And as I said, traditionally, we haven't used revocable trusts a lot, but I'm starting to more because the backup in the court has started to get untenable. We're waiting months now to get probate when we used to only wait weeks. And that can really be hard for people, and it can impede the proper administration of an estate. So we are trying to speed things up and try to use trusts where we can. So you also, as I alluded before, if you have property out of state, then if you only had a will, once it was given probate in your home state, you would then have to take it to the ancillary state where your other real property is located. Lots of people have homes in Massachusetts or in Vermont or in Florida. You would have to do an ancillary probate in that state, and that can be an additional delay and an additional cost. So a revocable trust can be useful because if the title to that other property is in the name of the revocable trust while you're alive, it's still in the name of the revocable trust when you die. And the person that you have named as the successor trustee can step in and take over right away and handle that property without having to wait. So that's very useful. The last thing that a revocable trust is very good for is to deal with incapacity. If you become suddenly unable to handle your affairs, again, all of your property is currently in the trust and you have named the person who will take over if you can't handle your affairs yourself, and they accept their appointment and things move along. So that's another useful use for the revocable trust. Again, it works best when you make sure to transfer all of that property in during your lifetime. Almost always a revocable trust is paired with a will, and the will direct that any property that's not already in that trust will be transferred there by your executor. So they can work hand in hand. And then the last sort of basic estate planning set of documents you would have are healthcare documents. These healthcare and financial documents are different from the will in that they are operative while you're alive, whereas the will really becomes operative when you die. Similarly, the revocable trust, although it has some operation while you're alive, it's just really an alter ego, and the real meat of it doesn't come into play until after you die. So the healthcare proxy, which I'll discuss very briefly now because we'll talk about it further down the line. Healthcare proxy is used to name someone who you trust to make healthcare decisions for you and to communicate with health professionals if you can't do so yourself. A living will, not to be confused with a living trust, a living will is the document that you use to explain your wishes at the end of your life. If there's no real hope of recovery, what you want and how you want to be treated at the end of your life. We'll talk about that in more detail later as well. The last document in this category is a power of attorney. That is a document that allows you to name someone to handle financial transactions for you during your life. And that's a currently active document. We don't just spin those around. We have them signed and we hold on to them for when someone might need them. So we can talk about that, those documents in a little bit more detail as we go through. Carrie, I'll take the next slide and we can talk a little bit more about trusts. So a trust is a vehicle that allows you to set aside property to be administered by someone for the benefit, usually of your family, but maybe for a charity or a more ancillary individual. I've listed some of these types of trusts here. We can go into it briefly, but I'm going to swap for a minute and I'm going to talk about trusts for minors briefly because it links into the will and the revocable trust. So let's say you are an ordinary typical couple, you're leaving everything to the surviving spouse, and then the surviving spouse is going to leave everything down to issue per stirpes, meaning your children and their children if one of them is not alive. So in those circumstances, the likelihood is that at least one of those people is going to be a minor. Or, and I maybe this should have said trust for descendants because that's a little bit more accurate. Not everyone who can benefit from a trust is necessarily a minor. It's most useful for minors because minors can't hold property in their own name legally. You're all probably familiar with guardianship accounts, custodial accounts, which are used to hold gifts maybe from grandparents for minor children. But if you have real sums of money and they're coming directly in an inheritance, you want to make sure that there's a trust set up. The reason that I hedge and say that really these trusts are for descendants is because the kinds of protections that you can extend with trust don't just have to do with the legal ability to hold money. Let's say you are giving property down to your 3 children and one of them at the time you die happens to be going through a terrible divorce. And the assets that they would otherwise inherit might then be pulled into this divorce proceeding and potentially go in some measure to the divorcing spouse. Or maybe they would be deemed eligible as part of the calculation for support payments. And you don't really want those assets to be available for that either. When I typically draft trusts these days for descendants, we put a provision in that says, I'd like my descendant to get this money when they're 35, but if It's not a good idea. If the trustee looks and says it's not in their best interest to have those assets at a time, then don't do it. Hold back. Some of those types of provisions might say, well, if the descendant in question has developed an addiction, or if they've fallen under the sway of someone who is likely to make them part with their money, or if they are having a period of financial or marital stress that makes it not ideal for them to have money at that time. Maybe it's a trust for a minor, and as they age, they are demonstrating that they really can't handle their finances on their own. You do want to make sure that you have built in these sorts of protections for any descendants. Now, those trusts frequently fall under your will. Those trusts are called testamentary trusts. They're trusts that happen under your will. Trusts for minors and descendants fall into that category. Spousal trusts frequently fall into that category as well. Let's say you are in a second marriage situation and you want your property to be available for your surviving spouse while they're alive, but when they die, you don't want that property to be under their direction and potentially going down to their children. You'd rather preserve it for your descendants. You can put that property into a trust under your will that will be available for that spouse during their lifetime. And if somehow they need all of the money, then fine. But if they don't, it's preserved for your descendants after the death of that surviving spouse. You can also create lifetime or inter vivos spousal trusts. You can set money aside to be used for a spouse and then provide where that would go on their death as well. So these are the other kinds of trusts. You have testamentary trusts that happen under a will, and then you have inter vivos trusts that are created during your lifetime. So I'm going to pop back up to the life insurance trust because that's a common question. People sometimes ask, well, I've heard that if I have life insurance, it's not taxable in my estate, and that's not true. Any asset that you own on your death that is registered in your name, whether it's life insurance or a retirement account or a bond or a stock account, all of those assets will be includable in your estate. If it's only in your name, then it will have to go through probate, but certainly it will all be in your name for tax purposes, for purposes of determining whether your estate is subject to estate tax. So one of the techniques that we will use for life insurance is we'll create a standalone life insurance trust. Sometimes it's called an ILIT, an irrevocable life insurance trust, ILIT. And if you have a life insurance trust like this, and if you ideally set it up before you purchase your life insurance policy, then you have the trustees of the trust purchase that policy. Now you've never owned that policy. It's not in your name when you die. And those assets can go into that trust and can be available for whomever, your spouse, your children, anyone else that you choose, without being subject to tax. To get a little bit technical also, if you own a closely held business or if you have assets in your estate that are not otherwise liquid and you think that there's going to be estate tax, you can use a life insurance trust to generate some cash to cover that estate tax burden. The life insurance trust that has the cash after your death can buy out an illiquid asset from your estate, swapping it for the cash. And now the estate can use the cash to pay the tax, and you don't have to do a fire sale of an asset that otherwise could generate value for your family. So a life insurance trust is an excellent tool. Even if you already have an existing life insurance policy, you can create the life insurance trust. You can transfer that policy into the life insurance trust. And then if you survive 3 years from the date of the transfer, the property is out of your estate. As though you had used the other technique, and now you've got free cash in the life insurance trust available for your family or for any other cash needs that there are. So this leads again to trusts for tax planning. So I alluded to the idea that you can use these life insurance trusts to have available cash to cover tax. There are some more sophisticated tax planning trusts that you can use. Many people have what's called a qualified personal residence trust, sometimes called a QPERT. That is the kind of trust that allows you to transfer your residence into a trust for the benefit of your issue who would receive it, usually your children, at the end of the trust term, so 10 or 20 years down the line. The advantage of that is that, let's say you have $1 million house. the value of the right to receive $1 million house in 10 years isn't $1 million, it's something less than that. So you can take a discount on the value of that asset, put it into this trust, and now you've gotten that asset out of your estate for a lower value than you would have before. There are other types of trusts for tax planning, which I won't get into too deeply, but you can use them to either freeze the value of assets in your estate. You can use them to provide charitable gifts, either at the front, which is called a charitable lead trust, which allows you to give money to a charity for a certain number of years and then have the remainder go to your family. You can use a charitable remainder trust, which is the reverse. It gives money to individuals for a term of years, and then the remainder goes to a charity. And those are very useful tools for tax avoidance or tax minimization. Let's talk a little bit about special needs trusts or supplemental needs trusts. And this will raise the issue of relatives with disabilities. More and more frequently, we find that people have either direct descendants or ancillary descendants, meaning nieces and nephews, or cousins, siblings, who have some sort of disability, autism, cerebral palsy, other disabilities that mean that they will always need some form of assistance. One of the catches is that if they have assets in their own name, they may not qualify for many of the services that are essential to making sure that they can properly function and have the support that they need throughout their life. So you get into a bit of a catch-22. You want to make sure that you can benefit this relative who needs help, but you can't really give them the money or else they won't be able to qualify for benefits. And the benefits that they receive in many cases can't be replicated privately. A lot of these are provided by governments. Think about Medicaid, for example. Medicaid for disability is a huge source of support. And if someone has left a bequest unknowingly to a person who's receiving Medicaid, they could be suddenly become ineligible for the benefits that they've been receiving. And that can be hugely disruptive and very harmful. And obviously, if you're leaving the money, their goal isn't to do them harm. So we can set up what's called a special needs trust or a supplemental needs trust. There's federal statutes that allow for that, and also many states have their own separate statutes providing for this. New York is one of them. And what those trusts provide is that the assets held in those trusts will not be used for the kinds of things, food, shelter, medical care, that are covered by benefits, but they are only available to supplement the person's care. So it can help them buy clothing. It can help them with leisure activities, vacations, the kinds of things that enrich life, and that can be particularly helpful for people with a disability. These trusts can be either testamentary trusts or inter vivos trusts. So if you, and many of my wills will also have a provision that says, I don't know what the future holds. I'm leaving a gift to these various beneficiaries. And if it turns out that at the time that they're going to get this money, somebody has a disability and they're getting government benefits because of that disability, and getting this money would otherwise harm them, then instead of giving it to them outright, or instead of putting it in the kind of trust that I had otherwise designed under my will, put it into this sort of special needs trust. And we sort of shut down the provisions to make sure that they can only use the money to cover the types of things that these supplemental needs trusts will allow and still qualify them for their benefits. You can, as I just said, set that up also as a standalone trust. So you can have the Mary Smith Supplemental Needs Trust, and it can be a standalone trust that maybe you start with $100. The benefit of doing that is that if there's more than one person who you think is ultimately going to want to leave money to Mary Smith, everybody can direct their bequests to that same trust. So grandparents, aunts, uncles, everyone has at the end of the will, when you get down, I give my money to my spouse and then to my children and then to my grandchildren. When you get to the point of considering where your property might go, if none of your direct descendants to survive you, and that, believe me, is everybody's favorite question in every estate planning meeting. Nobody wants to think about it. Takes a long time to come up with an answer, almost as long as it takes to come up with an answer for who the guardian of your children could be. That's really hard too. But when it comes down to that, frequently people will select collateral relatives, nieces and nephews, or cousins. And those people are a little more removed from your life. One of those people may have a current disability. One of them may develop a disability. You don't know who's going to be alive when you go. And that one of those end takers may be someone who, at the time you're drafting the will, doesn't even exist yet and has a disability. So you can direct that property would ultimately go to, if it's someone who's alive and you've got it, it's standalone supplemental needs trust, you can direct property into that supplemental needs trust. So these are all things to take into consideration, and they're the kinds of questions and topics that you should discuss with an estate planning attorney when you meet. Let's see, have I left off anything that I wanted to talk about? So let's talk briefly about spousal trusts. When we were talking at the very beginning about the estate tax exemptions, I alluded to the fact that New York allows you this $6 million exemption, and that if you do it properly, you can use 2 of them between 2 spouses. So unlike the federal government, which allows you to use both of those exemptions on the second death, in New York, you have to use it at the time of the first death or you lose it. So if you have a joint estate between 2 spouses that totals about $10 million, and the surviving spouse inherits the whole thing, now that survivor suddenly has $10 million, and when they die, they only have an exemption of 6. So you've lost the ability to shelter all of that $10 million. Instead, on the death of that first spouse, the survivor can elect to put trust property, or the will can direct that property will be held in a trust for them. And typically that would be up to that $6 million amount that you can give away. So now if you have an estate of $10 million and you can put 5 of it into a trust, that trust will be available for the benefit of the surviving spouse throughout their life. If they need it all, then great. If not, it stays there, and it can be available to go down to children later on in life. So this is another thing you have to discuss with your estate planning attorney, what you've got. You're counting all of your assets. You're counting if you have life insurance from employment, if you inherit property from other people, if you have a house. You want to make sure that you're using all of the tools that are available to you to make sure that as much as possible can go down to your family. Okay, let's go to the next slide, and we can talk a little bit about our financial and healthcare documents. So your healthcare proxy. This is a really important document. It might be the most important one here next to the will, and even maybe a little more important than the will, because it is the document that makes sure that your health ultimately is preserved. So if you are in a situation where you can't communicate with your physicians, and that you might not be terribly or terminally ill, maybe you've had surgery, and in the middle of the surgery, there's a question that needs to be answered. You have to name somebody who the doctors can rely upon to discuss your healthcare, and who can make decisions for you. Now, it can be tricky to decide who that person is going to be. Some people have a natural selection. Maybe it's going to be your spouse in the first instance, and then one of your children has a particular affinity for this sort of thing, or who tends to take the lead. And then who you're going to name. It's a little tricky because you can only name one person at a time. So you can't name 2 or 3 people to act together. That's a recipe for chaos and likely to be ignored by the medical professionals. They need one mouthpiece. You can ask that if you name your children, maybe you're going to name them in age order, that they consult with each other in making decisions. Maybe one of your children, I'll tell you that in my family, one of my relatives has 2 children, one of whom would keep her alive forever, literally forever, and the other of whom would probably pull the plug because of an aggressive hangnail. This is not what the person wants in either case. She wants someone who's got a slightly more measured approach. And so she's named a friend who she trusts to have a similar position as she does on these types of issues, to act as her healthcare proxy. So as I've just alluded to, the healthcare proxy will act in accordance with the instructions that you've given, and some of those instructions are given in a living will. A living will is the document that you will use to tell people what it is that you would want at the end of your life. If there's no real hope for recovery, or if in your view, there's always hope for recovery, a living will is the document that you will use. Not everybody has one. I have some doctor clients who say, they're not worth the paper that they're written on. I don't think that I'm going to have it. But there are some people who feel very strongly, and I think that it's a useful tool, to be able to tell your family, look, it's okay if you think that there's really no reason and that it's not going to be a life the way that I want it to be, then you should feel comfortable making a decision to, for example, withdraw life support. 99% of the time, this is a decision that's not made by people. It's a decision that's made by nature. But it can be reassuring to your family to have it written down in a place that they can see that you documented what it is that you want and don't want. And so those documents will work together. The power of attorney, as I said, is a currently active document that you can use to give someone the power to handle your financial affairs. We typically also use that. We expand that so that the person who's given your power of attorney can do tax planning for you. If you're incapacitated, the power of attorney is still available as use, and together with the healthcare proxy and living will, it can, instead of, if you don't have a revocable trust, these documents acting together can enable someone to help you navigate the process of incapacity. And the power of attorney can create trusts, designate beneficiaries on assets like IRAs or a 401k or a life insurance policy. And so those documents can be very important, but you should discuss them and read them carefully if you're working with an estate planning professional to make sure that they say what you want and that they're helpful for you. Let's move on to the next slide, and we can talk a little bit about planning with gifts. So, as we discussed before, you can make gifts to descendants outright. You can make them during your lifetime. Many people are familiar with the annual exclusion gifts. It used to be $10,000 now, thanks to inflation, it's up to $16,000 that you can give to anyone and as many people as you like during your lifetime. You can give those gifts outright. And again, if you're giving them to minors, whether it's children or grandchildren or nieces or cousins, you put those into either you put them into a uniform transfers for minors account. Those are the custodial accounts that you're probably used to working with. Two people, a married couple, can give twice that $16,000. So that's a good way to start making gifts to people that you care about, and there's no tax consequence to you. Those are free gifts. We talked a little bit about gifts of tangibles, gifts of items that you own that have sentimental value to your family members or friends. You can either put those gifts in a will, you can make them outright during your lifetime. 529 accounts. These are really good tools for providing for education. People are used to starting to use these for grandchildren most commonly. That's $16,000 a year or $32,000 from a couple. You can put it into a 529 account, and that property will grow free of tax and when the beneficiary is ready to go to college, or in some cases private schools, you can use some of it for private school. That money is available and can be withdrawn free of tax to cover tuition. So that's a really, really useful tool. There is a section of the tax code that allows you to pay directly tuition expenses and medical expenses for anybody in addition to that $16,000. So if this happens a lot of the time with grandchildren going to nursery school and you want to help cover their nursery school payments. I've seen that a lot. You can pay that as long as you pay it directly to the nursery school. It's not an additional gift. It's under a separate section of the code, but it's not a taxable gift. So you can still make that gift as well. You can put your annual gifts or other gifting into a trust for a minor that can then grow. That would be available for them instead of putting it into a custodial account. If you would rather not have it under the custody of a parent, you can put it into a trust with the trustee that you name. Gifts to charities. So as we talked about before, these can be very useful gifts for planning. Certainly if you have established a relationship with an institution and you've given time during your lifetime, you might want to honor that, as we said, with a small gift under your will. You might want to make larger gifts, either endow a scholarship in someone's name or honor. You might want to do an endowed charity at an institution, or maybe give money to a medical institution. You can make gifts from your retirement accounts. There is a new provision that allows you to, instead of taking your required minimum distribution, if you don't want to take all of it yourself, you can direct it to go to a charity, and that will satisfy your required minimum distribution and give you the charitable deduction. So as I said, you can make cash gifts either in your will or during your lifetime. You can give gifts of other types of property. You can give gifts of artwork to charities. Some people like to give art to museums. You have to be a little careful because they won't always take it. So that's a good idea if you do have a piece that you think a particular institution would want. It's a good idea to discuss it with them ahead of time to make sure that they will take it. You can, like I said, make gifts in trust to charities using charitable lead trusts, which give the gift to the charity ahead of time and then preserve property for your family later on. Or you can use a charitable remainder trust that allows you to benefit family members ahead of time and then leave the balance to charity at the end. So that sort of covers, I think I went through it pretty quickly. So hopefully there'll be some questions and I can slow down a little at the end. But the last thing that I want to leave you with, and Carrie, this is sort of the last slide here, is that the legacy that you leave behind really doesn't have anything to do with what you've got. The real legacy that you leave behind is the relationships that you have created with the people that you care about during your lifetime. If you leave more tension in your wake, then I personally think that that's a failed estate plan. For me, the primary goal is to make sure that the relationships work after you go, that nobody feels like they've been left out or cheated. Look, everybody has family issues, and there are ways that we can account for estranged relatives and people who you think need more than others. But ultimately, a real conversation about your family dynamic is one of the most important, I think, conversations you can have with your estate planning attorney. It's more important than taxes. It's more important than, who gets which piece of jewelry. Ultimately, that's the thing that I think is most important. And that's all I've really got to say. I'm hoping that if there's some questions, I'm obviously happy to answer them.
Great. Thank you, Sharon. That was fantastic. And I love the way you present and the real life examples. So thank you. Thank you. We are about to go into the Q&A period, and I've already gotten a bunch of great questions that I'll share with Sharon. Before we go into that, I'm going to take 2 minutes to jump in on something that Sharon spoke about, which is the gifts to charities. The fact that you are here today through Westchester Community College says that you know and understand the important value of Westchester Community College to our community in terms of giving our neighbors an excellent educational experience and opportunities. So if you do consider naming a charity in your estate plans, we really hope that you will think about the Westchester Community College Foundation. Westchester Community College Foundation provides about $2 million in scholarships and $2 to $3 million each year in other programmatic support to the college. Just recently, one of our alumni made a bequest in his will to establish an endowed scholarship in memory of his wife, who had encouraged him to pursue a higher education starting at WCC and beyond. As Sharon alluded to, there are ways to establish a gift that will bring a income during your lifetime and tax benefits, such as establishing a charitable gift annuity, which we do here at WCC. Anyone who names the foundation in their estate plans becomes a member of the Hartford Hall Society, and members are invited to an annual reception starting in the spring, where they receive a special, beautifully designed pin and a certificate. And that's really all about spreading the word about Westchester Community College. I believe that my contact information is about to come up. So if you have any questions or are interested in learning more, please feel free to reach out to me either by email or phone, or just pop in. I'm on the second floor of Hartford Hall. We are about to go to Q&A, but I know that not everyone will be able to stay until the very end. So let me just very quickly say thank you to Sharon for a wonderful talk. Thank you to Carrie Colon Lopez for arranging this event today. Thanks to Michelle Schleibaum and the Alumni and Council for co-hosting with us. Thanks to Mitch Udolph for doing our tech, and all of the folks at the foundation and the college who helped to present. Now I'll go to the first question, Sharon, if you're ready.
Sure, go right ahead.
Great. Will a list of recommended documents be posted after this presentation?
So I would think that you could look at the slides. I don't know if the slides will be posted somewhere, Dolores, but that might give you a way to have a list. I think everybody needs something different, but the really basic documents would be a will, a healthcare proxy, a power of attorney. That's really the three basics that I would think everybody would want to have. Beyond that, it would be a question of what you and your estate planning attorney determine is optimal for your particular situation. And again, everybody's different.
Okay. Second question, do couples draw up separate estate plans?
In New York, they do. You have a will that is your own will. Other states do it differently. California does things jointly, and I find it frankly hard to understand because it's not the state that I practice in. But yes, every spouse would have their own separate estate plan. You would expect that they would be coordinated. And most of the time, spouses will have mirror image wills, right? So my will say, I give everything to my husband, and my husband's will say, I give everything to my wife. And then on the death of the survivor of us, the wills both say that it would go down to our children subject to certain trust terms. Sometimes, though, if you have a situation, for example, in a second marriage, those wills might not be mirror images. They might say slightly different things. Someone who is divorced might have obligations under their separation or divorce agreement that have to be honored by their estate. So those provisions have to be included in a will. But yes, separate estate plans for each spouse, likely coordinated, though, to make a plan that works for everybody.
Great. Does your planning stay as is in the future if the laws change? So are they grandfathered?
So they're not grandfathered. Your plan is your plan. What may change is the tax laws. So if you say, I give everything to my Uncle Jerry, and then if Uncle Jerry doesn't survive, I give it down to Cousin Sue, that's what's going to happen. But and again, your assets are going to change between now and the time that you die as well. So the fact that at the day that you do the will, you have an estate of $3 million and Uncle Joe is alive, when you die and 40 years later, Uncle Joe isn't alive and your estate is now worth $15 million, the tax laws may have changed. The tax laws that were in place when you did the will not stay, right? The tax laws that will apply and the laws that will apply to your estate are the laws that will be in effect on the time that you die. And this is why it's a good idea to review your estate plan every few years. We do alert our clients if there's been a major change in the tax law. And certainly if the circumstances of your world, right, the people in your world have changed, that's a good time to review what your estate plan says.
Great. Here's a question that's close to my heart. We don't have any children and want to leave some to their nieces and nephews, but also would like to support a charity and a foundation or foundations, and they don't really know where to start. How do they decide on what would be the next steps to including a charity in their estates?
So that's a good question. And I think the answer is that you need to look around at your own lifetime giving. Try to settle in on what your priorities are for charity. Maybe you're focused primarily on education. Maybe you're focused primarily on a particular medical issue, right? The Alzheimer's or heart conditions, or something more specific. I have one client who had a daughter with a very rare gastrointestinal tumor, and so his will makes a provision for a gift to a foundation that was created specifically to do research into a cure for that particular disease. So I think honoring some of the commitments and causes that you have honored during your lifetime is a good way to start. If you have more general thoughts, then it's a good idea to sit down with an estate professional who can give you some guidance, right? Maybe you have lived in New York City your whole life and you want people to be able to enjoy the things that the city has to offer. Think of the institutions that you frequent most often. Maybe they're museums, maybe it's the Botanical Garden, maybe it's Central Park that you find most impressive or most engaging to you about where you are. Maybe you're in a smaller city, but maybe there's not a dog park. Maybe you want to start give money to start a dog park. I've had clients come up with all kinds of things. There's almost too many choices. So I think it's a good idea to start with the things that have been important to you or people close to you during your lifetime. I do have one client who she left property to her 3 children, and in each, so there's 3 shares. And in each case, if that child or their issue don't survive, she asked the child, where would you want that share to go? And so each child picked something that was important to each of them. One lives in a coastal city in Maine, and there's some sort of lighthouse foundation. One is very involved with an equine rescue foundation, so that one, and one is very interested in cures for mental illness, and so that person chose that. So I think asking the people who are involved in your life, they may have ideas that you haven't considered.
That's great. Is there a limit to how many power of attorneys can be included for one person?
Not really sure what the question is. So if you are asking, can one person be appointed power of attorney for 100 people? The answer is yes. I don't recommend that. It's not a great idea to have one person having power of attorney for everybody. If you're talking about how many people you can name, the document allows, at least in New York, the New York document says that there's room typically for 2, and you can opt to have them act separately or require that they act together. Sometimes we can add a 3rd in, but I wouldn't recommend giving that kind of power to too many people all at once. You want to sort of narrow it down a little bit. But if you have 3 children, you can name the 3 children, and then you can either initial that they will be able to each act alone or require that they have to act together. Sometimes that can be better for family harmony, sometimes not, depends on the family.
Great. We have a lot of questions, which is great.
That's great.
What are your thoughts on Medicaid asset trust?
So that is something that you really would need to discuss based on your personal circumstances with a professional. We do that at my office. I don't do it as much as one of my partners does. Medicaid protection trusts can be very useful. They really can, if you are eligible, if you need for someone to be eligible for Medicaid services, then there are things that you can do. There's a lot of documentation involved in the application process. And if you need Medicaid, if you are talking about trying to set up a Medicaid trust well in advance of your needs, that would be at least 5 years in advance of thinking that you might need to apply for nursing home care. I'm certainly not against it. I think depending on your particular circumstances, you might find it too restrictive. But again, it's not really a question that I can answer very generally, because that sort of planning is very specific to your circumstance, and it's a state-by-state issue as well.
Okay, I have a two-part question. Who manages the Special Needs Trust? And also, who ensures that the Special Needs Trust monies are being administered and withdrawn properly, such as for clothes, trips, and so on? And if the administrator dies, should a contingent administrator be identified? So
yes, you're always going to have, you're going to have a trustee of that supplemental needs trust. If it's under your will, it's going to be somebody that you name under your will. And you will provide optimally for at least one, if not two successors in line to that person. Wills typically also have a provision that says the last person who's acting, if there's no one named after them, they can name their own successor. And if there's a total vacancy, a court will step in and will name someone. But that you can dictate that in the document. If you have a standalone separate special needs trust, similarly, you will also name successor trustees, and you'll have a provision for there to be successors appointed. As for who makes sure that it's being done right, ultimately, the beneficiary will, the state will sometimes get involved, is sort of the short answer, because Medicaid, if it thinks that there's an asset it can attach, will want to attach it. So the trustee is going to have to, there'll be reporting that has to be done. Again, that's a state-by-state issue, and it depends sometimes on the types of assets that are in the trust. So that's something you'd have to discuss more in detail with someone. But there is, the courts can have oversight, the state can have some oversight. It's not simple, but when it works well.
Okay, I have related questions. If I give a gift of $16,000 in my will to each child, do they need to declare it as income? And how does it relate to the $6 million exemption in New York?
Okay, so let's back up a little bit. That is a more complicated question than you think it is, for the following reason. The $16,000 that you give are gifts that you give during lifetime. You certainly can give a gift of $16,000 under your will, but you're not limited to that under your will. That $16,000 is the amount that you can give before you would have to eat into your federal exemption amount. And the federal exemption amount is $16,000. I'm sorry, the federal exemption amount is $12 million. So if you're giving $16,000 a year, you're not really going to get up there unless you have, 2,700 nieces and nephews and grandchildren. And some people have a lot. But so that's if you give more than $16,000, you'd have to file a gift tax return. That's really that's the main irritation there, is that you'd file a gift tax return. So I gave a gift of $20,000, 16 of it comes under the exemption. I've now used $4,000 of my $12 million exemption. And each year you'd report that and it would be cumulative, because the federal amount is an amount that you can give either during your lifetime or upon death. And so they count what you give during lifetime up to that number. The New York $6 million, New York doesn't have a separate gift tax. So you can give that $16,000 and it doesn't really matter. New York does, however, call back in to an estate gifts that are made within 3 years of death. So if you make a gift that's in excess of that, you may be using up more of your 6 than you realize, depending upon how much later you die. That is, again, I'm simplifying and I'm not even really getting down to the real complexity. To answer the other question, no, gifts that the $16,000 gift, whether you give it during lifetime or if it's in your will, it's not income. It's a gift of principle. Gifts that come under a will do not generate any tax. So if you give someone $100,000, they don't report it as a taxable, it's not income to them at all. The estate tax that is assessed at the estate level. So if there's an estate of $10 million and your exemption is 6, the estate is paying that tax before the individuals get their money. So the individuals don't have any tax to pay on, we don't have an inheritance tax in New York. There's no tax on the inheritance.
Great. Is there a look back period after creating a trust to transfer to your children?
So as I just alluded to, any gift that you make in New York, there is a look back period of 3 years from the time that you die. And that's the same for the federal government. So if you make a gift into a trust, then, and because that's how you would fund the trust, you'd fund it with the gift of property, there is a period of look back and it's 3 years.
Is there a certain age when people should set up a trust?
Well, you have to be of the age of majority, so you have to be a minimum of 18 years old. But no, it's not really age driven. It's more circumstance driven. Somebody asked about Medicaid trusts, right? If you can anticipate that you think in 10 years you might need to go into a nursing home, maybe that's the point you're going to try to set up a Medicaid asset trust. If you're setting up trusts for other people, it doesn't really, they just have to be alive for you to be able to set up a trust for them. So it's not really an age-driven concern. It's more the circumstances of your family and your asset class and where you live and what the tax exposure might be.
Should you discuss with your beneficiaries of your will what they are going to get upon your death, or keep it as a surprise?
So that depends on what you're talking about. If you're leaving a friend $15,000, you might not want to mention that for 2 reasons. First of all, you might change it, right? And it's not your last will and testament until it's the very last one that you do. You could change it all the time. I don't recommend it as a hobby, but there are people who call me more frequently than they should to say, oh, I'd like to update my will. So you don't necessarily have to tell people about gifts like that. If you're talking about your children and you want them to have an expectation or an understanding of how your estate will be divided, either because you want to be open with them about what your plans are, or because they have their own estate planning that they need to do at some point and they want to have an understanding of what their inheritance might be, it's perfectly fine and you're certainly not prohibited from talking to anybody about this. But there's no reason not to talk with your family and say, everyone's going to be treated equally, or or conversely, let's just say, I have one relative with 2 children, one of whom is fabulously wealthy and one of whom is a public interest worker. That person has sat down with the family and said, look, I love you equally. I want to treat you equally, but you know that your sister needs more than you do. So I'm not going to, so I'm making that provision in my will. That kind of thing shouldn't be a surprise, right? That kind of thing, you don't want the mother to die and think that everyone's being treated equally and all of a sudden find out that she's decided that your sister needs more than you do. Also, people's life circumstances change. Just because somebody needs more today doesn't mean they will need more in the future, or somebody needs less today, they won't need more in the future. So those sorts of things, if it's with close family and you otherwise would be harming the relationships that you leave behind, those are the kinds of things you want to do. But if you're leaving other gifts like that, and not to put too fine a point on it, but charities also, if you think that you're not going to stick with that gift, you don't want to give the charity a false hope that they're going to get a gift that they may not get.
Thank you. One participant asks, all of my bank accounts and retirement accounts, et cetera, ask for beneficiaries. Does that stand, or do we need to also include that in the will?
So I'm going to separate out things like life insurance policies and retirement accounts from straight bank accounts. Life insurance policies, 401ks, IRA accounts, 403b accounts, KEO accounts, those things have to have a designated beneficiary. Those you want to pass outside of your will, and they will go per the beneficiary designation. You could say something different in your will, it wouldn't matter. Bank accounts, on the other hand, and I've found this recently, I've had a lot of clients saying, oh, my bank called and said I have to put a beneficiary on my bank account. You do not have to put a beneficiary on your bank account. And much of the time, you should not put a beneficiary on your bank account. because now you will have defeated your estate plan. Now that property will pass outside. And let's just say you were going to give it to a child and that child predeceases, and now it's going to go to your grandchildren outright instead of in the trusts that you carefully created under your will to make sure that they would be protected. If you've named a beneficiary on that bank account, now that property isn't going to go through your will. So it's in fact the opposite of what you say. Those documentations will stand, and regardless of what your will says, those documentations will stand. I find it really irritating that the banks are doing this. It's easier for them. They just want to know that there's a name on there, and they're misleading people into thinking somehow that they have to do this and that it's a good idea for everybody, and it's not. So thank you for raising that.
So
Gives me a chance to rant.
Should you put that it's going to your estate if they?
You don't need to.
You don't need to. Put
No,
that
you don't need to. If it's in your name alone on your death, it will pass through your estate.
If you created your own will, where should you hide it? And what is the problem with doing your own?
So the problem with doing your own will is that for the most part, that wills are complicated. And that the types of clauses that you would want to have in there, you wouldn't know about. And it's not just because I could, because I do this for a living that I say this, but I make more money fixing the mistakes that people make when they try to do something themselves than I would have made if they had just done it with me right in the first place. That's my personal experience. It's not a great idea. You wouldn't, do your own electrical work because you might, shock yourself. Some people maybe can, and that's great. You can do your own electrical or your own plumbing, but as a general matter, you want to at least consult with somebody. If you've done it, have somebody look at it, right? Who can tell you, oh, maybe this tax clause isn't right for you. Maybe, you've left off something. You don't have a power in here allowing your fiduciaries to do something that they should be able to do. Or because you don't have this clause in here, now your fiduciaries are stuck, they have to put up a bond. And that's going to cause a problem. So there's things that you could be leaving out without knowing it. As for where you hide it, I can tell you where not to hide it. Do not put it in a safe deposit box, because when you die, no one will be able to get into your safe deposit box. Even if somebody else's name is on there, it will be shut down and you'll have to petition a court to get it open. So if you have an original will in your possession, do not put it in your safe deposit box. Most of the time, if you do a will with an attorney, we typically keep the original will in our will vault. We lock it into a fire safe vault in our office. And that is because if the original will is in the possession of the person, the testator, the person who wrote the will, and it gets lost, the presumption is that it was revoked, because only the person who did the will can revoke the will. And if it's gone, they're going to presume there was no will. And now you've put all that hard work in for no reason. If the will is in the custody of the attorney and it gets lost, the presumption is that it's lost because the attorney doesn't have the ability to revoke that document. And then you can have a copy admitted to probate. So
I have a question. Can you please explain about the lifetime exemption for green card holders? They have the same, do they have the same life exemption amount, $12 million, as US citizens? Yes,
permanent residents have the same exemption as citizens do. The one thing that you have to be a little bit careful about is if you are trying to leave money to, so one thing we didn't talk about with respect to tax is that any money that goes to a citizen or permanent resident spouse is free of estate tax. So we only usually worry about there being estate tax on the second death of a couple. The exception is if you have a non-citizen spouse. You cannot leave an unlimited amount to a non-citizen spouse because the government's position is that non-citizen spouse will take their money, pick up, leave the country. And now when they die in the future, we don't get our tax amount if there's anything left. So there are separate provisions that you have to be careful of if you have a non-citizen spouse. Similarly, when you make gifts, you can make unlimited gifts between spouses who are citizens. But if you have a non-citizen spouse, you're limited. I think the number this year is $160,000 is what you can give to a non-citizen spouse.
Great. Okay. How do you form a trust to shelter assets in the event that one or both of you go into a nursing home? And if you have such a trust, do you still need long-term care insurance?
So that is a question that really is is hard to answer in the general. You create, this is the Medicaid trust that somebody was talking about before. That is the type of trust that you would create if you wanted to be eligible for Medicaid coverage of a nursing home stay. And again, it depends on the types of assets that you have, how they're held. It is very technical. It is a state-by-state thing, and it's hard for me to answer here, but you would consult with an estate planning attorney, and they would tell you whether or not it's optimal for you to create that kind of trust. Long-term care insurance is an excellent thing to have if you can get it. And certainly it gives you, if you are in a position to need to apply to a nursing home and you haven't yet set it up so that you have a trust, the long-term care insurance can cover some of that nursing home care. I think they tend to work together, but again, your circumstances are going to be different from everybody else's. And so you'll really have to discuss those issues directly with an attorney.
How much should we expect to pay to set up a basic trust?
I'm not really sure what you mean by basic trust, because trusts don't tend to be pretty basic. But if you're talking about a basic estate plan, that can vary. It can vary. Maybe it'll be between, again, depending upon how complex your situation is, and you may not know when you go in what complexities you have until the attorney has been able to analyze that. But I would say generally a simple estate plan maybe would be between $2,000 and $5,000, depending upon who you're working with.
Great. I have a question of whether you, Sharon, are taking any new clients from a participant who doesn't have an estate planning attorney.
Yes, I certainly am happy to talk with anybody who has any questions, and we are available to help.
Great. And a related question, how do you go about finding an estate planner?
An estate planner? So I would recommend that you ask either a trusted professional, whether you have a financial advisor or an accountant. They can be a really good source of people. It is there are accountants that I work with pretty frequently, and it's nice to be able to work with the accountant because then we get good information. You can ask your friends who they've consulted with. I get a lot of referrals through other clients who have been happy working with me, and then they want their friends to be happy too. So I would ask family members, friends, other trusted professionals that you've got in your life who they work with. There's a lot of us out there, like a lot of other professional relationships, it's personality driven. There's somebody for everyone. I'm not everyone's cup of tea. So ask around, find someone who you think that you're comfortable with, and don't be afraid to call more than one person. Really shop.
Someone writes that she has property in New York and overseas. Are there special attorneys who can handle both local and overseas assets?
So I do a lot of cross-border estate planning. I'm bilingual, I'm fluent in French, and so I have a good amount of experience dealing with assets in France and in the UK, but I'm not qualified to practice law there. And one thing that I can tell you is that all countries are different. And the best course of action really in the end is to have one will that deals with your US property and then a separate estate document that deals with your assets in the other country. Local laws can be very, very, very different. Just to give you an example, in the US and in New York, you can't, like I said before, disinherit a spouse without their permission. In civil law countries like France, Italy, Spain, it's your children that you can't disinherit. So it's exactly the opposite. Here, you can disinherit your children until the cows come home, nobody cares. But there's a part of your estate that you cannot give to anybody else. So you have to be very careful to observe the local laws and to consult with a local attorney, which we do a lot. And sometimes we'll coordinate. I'll coordinate with the overseas attorney to make sure that the plans work together.
Okay. If I move to another state, do I have to redraw all of my estate planning documents in that state?
You do not. So documents that are valid where they were signed, when they were signed, will be given the full faith and credit of each state of the United States. But if you are going to change your documents after you've moved to that state, in all likelihood, the new attorney that you'll work with in the new state will do new documents for you because you'll want them to conform to the state where you are then living and drawing up the documents. But if nothing's changed, you can keep those documents, and any state will honor them.
Can I name both of my children as executors?
Yep. As long as, and again, this is a family dynamic question. You absolutely can legally name them. You can name 4 children to act as executors together. Just make sure that they get along and that it's not going to make things harder if you name them to act together.
Here's a question that I can answer. Will the recording of this session be available for later listening? And the answer is yes. We will post it and make it available. I have a question about being a trustee. Can you quit being a trustee anytime? What kind of paperwork do you have to do if you change your mind about being a trustee?
So the answer is yes, you can quit. If you've accepted to be a trustee under a will, under a testamentary document, that means you were appointed by a court and you can resign, but typically there's going to be some sort of court involvement in making sure that there's a new successor and that your resignation is approved. If you are resigning, you probably will want to be released by the beneficiaries of the trust so that you're not surprised later on somebody doesn't come back to try to sue you for something that they think you did wrong while you were the trustee. So I wouldn't recommend resigning without making sure that you've got an attorney representing you who can get you properly released from being a trustee. If you're talking about an inter vivos trust, a trust that was created by someone during their lifetime, yeah, you can still resign. There's not going to be any court involvement, and you'll just want to make sure that before you step out, somebody else is coming in, and that will depend on the document itself, which should have some provisions. If there aren't provisions, then you would still have to go to court. I've had that happen with some poorly drafted documents. We've had to go to court to have the court appoint a trustee of an inter vivos trust where there was no successor. And again, you'll want to make sure that you're properly released by any of the beneficiaries before you skedaddle.
Okay. This is a follow-up to what you mentioned about the safety deposit boxes.
Yeah.
It says when you die, your safety deposit box gets locked. If your will specifies a beneficiary for your box, can the beneficiary get access?
Yeah, that's a practical answer. And the likelihood is no, because banks are very skittish about dealing with safe deposit boxes. Here's my advice to people when they call me. I say, if there's a safe deposit box, before the bank knows that the person in question has passed away, you plaster on your happiest smile, and if your name is on that box, you go down to the bank and you take everything out of the box. Because it really can be very distressing to people, but the box will be locked down and the bank just won't let anybody in. And when you do go in, they'll have to do an inventory and other people are there, and it's not great. I wish I had a better answer, but the banks they're just so skittish about giving access to anything.
I have giving a gift to a non-citizen spouse is tax-free up to around $165,000, but is that $165,000 per year or $165,000 in a lifetime?
That, I believe, is an annual amount.
What kind of estate planning attorney would handle a Medicaid trust?
So there are elder law attorneys estate planning attorneys who specialize in elder law. We have them at my firm, and there are plenty around, but you would want to look for an elder law attorney, someone who says they specialize in elder law.
Okay. If you don't have children, how can one find an executor?
So another good question. You can look to your friends. You can look to other relatives, nieces or nephews. You can look to your accountant. Sometimes people will have their accountant act. You can have your financial advisor act, as long as they're not a broker-dealer. Broker-dealers are not allowed to act as a fiduciary. You can name a bank. If you have enough assets, or if you have a good relationship with the bank, they will agree. You can have a professional fiduciary. Attorneys will sometimes act. I don't always do that, but it happens. There are some attorneys, older ones, used to put themselves in every single document. Oh, you have to name me as your. That always made me a little anxious. But you can have a professional act. It can be a friend. It doesn't have to be a family member.
Okay. What is the best way to help aging parents realize that they need to get their affairs in order?
Yeah, so telling aging parents anything can be a challenge. I hope to not be that parent when I get there, but chances are, given my general level of stubborn behavior, I will probably be as resistant as anybody else, not to this topic, but to others, I'm sure. So I think that the message is that, look, there are some people who are very superstitious about estate planning. They think that the minute they sign a will, it means they're going to die. And I have to break it to people sometimes that it's not a question of if you die, it's a question of when, right? The human mortality rate is 100%. And I don't know when things are going to happen or how, but I know that it's going to happen. So that can be a difficult issue to break through. There are people who really have a hard time contemplating their own mortality. But if you get through that, I think the best message is that estate planning really is a gift to your family. Leaving them with a set of instructions so that they're not wondering, they're not questioning, they're not concerned that they're going to do something wrong or somehow dishonoring your memory. It is a gift to leave your family with a plan. That's the most persuasive argument that I can come up with.
And at what age should an adult child have a will or other planning document?
So that can vary. I guess the answer also depends, again, on the family dynamic. So if you are an adult and you don't have a will and you're not married and you don't have children, your property is going to go to your parents. And most of the time, we don't like to pass assets up a generation because it means it's more likely that property could be subject to estate tax. And I know right now, the estate tax exemption is pretty high, but last October, there was a lot of talk that that exemption was going to go down to either $3.5 million, it could have been $1 million. It may not be $12 million forever. And so there may always be some risk that people would be exposed to estate tax. And again, we don't want property to be taxed sooner, we want it to be taxed later. So as soon as someone has any assets and is an adult and doesn't want their property to go to their parents, they might do a will that says, I instead give my property to my siblings. It's sort of a personal thing. I wouldn't say that the minute someone turns 18, they need a will. I will say, though, and so I'm glad that this has been raised because it gives me an opportunity to point out that the documents that your 18-year-old should have when they're heading off to college are a healthcare proxy and a power of attorney. The universities now will not talk to you because your child is an adult. So if you have a health issue or a financial issue that the child is dealing with, and you are not authorized by one of these documents to talk to the university as a healthcare agent or a power of attorney, they may not give you any information. So that's really important. I spend a lot of August doing healthcare proxies and powers of attorney for the children of clients who are heading off to school. But when they need a will vary. The minute that they have things that they really want to make sure that they leave to people that they care about and not what the law would say. When a child gets married, now their spouse is their beneficiary. So that's, a little bit better. But certainly your mileage will vary. There's no fixed age.
Okay. And the last question that we haven't covered is, can the executor charge a fee?
So executors are entitled to a commission by statute, and the commission is based on the value of the property being administered. So they don't have to charge a fee. They are entitled to a commission. Much of the time, if the executors are the children who are already inheriting the property, they don't take the commission because the commission is income to them, whereas the property that they inherit is not income. So it doesn't always make sense for them to take the commission. If one child is acting and they feel like they've been doing everything and, to the exclusion of the others, maybe you're going to have them take it. But again, it's income and it's going to increase their income for income tax purposes. So it's a case by case thing. But yeah, there is a commission. There's also commissions for trustees. Lower, but also based on the value of the property. There's a formula within the statute.
Okay, well, thank you so much, Sharon. That was so informative and I learned a lot. And I can tell by how many people have stayed on this call and all the great questions that others learned a lot too. So thank you, thank you. And yes, we will post the presentation online.
Thank
So
you, Dolores. It was really a pleasure to be here this evening. And I thank everyone for joining us and for staying on for so long.
great. Thanks so much. Have a good evening.
Thanks. Bye.
Bye.